Hello, my name is Meg Kinnear, and I am the Secretary General of ICSID. ICSID has amended its procedural rules for arbitration, conciliation, mediation, and fact-finding. This has been the most significant update to the ICSID rules in its history. The new rules come into effect on July 1st of 2022. In this short video, we highlight the key changes to the ICSID Rules 2022, and we'd like to preview some of these highlights that you will be working with in the future. We'd also like to share our plan for training and information that will be made available in the coming months. The ICSID 2022 rules were developed over 5 years through extensive consultations with member states, arbitrators, counsel, academics, and facility users. They were resoundingly approved by member states on March 21st, 2022. The text of the new rules has been posted on the ICSID website. You will find each set of rules in a separate booklet. The blue book is for convention cases and contains the ICSID Convention, the Executive Director's Report on the Convention, the Administrative and Financial Regulations, the Institution Rules, the Conciliation Rules, and the Arbitration Rules. The yellow book contains the additional facility rules, including Administrative and Financial Regulations, Arbitration Rules, and Conciliation Rules for additional facility cases. The green book contains the new mediation rules and administrative and financial rules for mediations, and the red book contains the new fact-finding rules and administrative and financial rules for fact-finding. These are currently available in searchable format on the ICSID website, and they will be available in hard copy through the Center and through Amazon Books over the next weeks. In mid-July, ICSID will publish an updated website that contains extensive commentary and explanation on each of these rule sets. The site will be dynamic and continue to grow over time with case tables, charts, and other information for ICSID users as we all gain experience under the new rules. Beginning in September, the Secretariat will also be publishing short videos on individual rules or rule sets, and will be doing presentations in venues in every region to explain the new rules and answer any questions. For now, here is a preview of some of the updated rules we'll be working with in the future. First, there is a new rule addressing third-party funding in arbitration and conciliation. It is intended to avoid inadvertent conflicts of interest between arbitrators and other parties participating in the case. This rule requires both disputing parties to file a written notice as soon as the request for arbitration is registered, or immediately upon securing third-party funding if that happens later in the proceeding. There's no special format for the notice, and it must simply state the name and address of the funder and the names of those who own and control the funder if it is a juridical person. The notice is sent to the ICSID Secretariat, which will circulate it to the disputing parties and the arbitrators in the case. Second, one of the key objectives of these amendments is to reduce the time and cost of proceedings, and you will see provisions throughout the rules that contribute to this objective. For example, there is a general obligation on both parties and arbitrators to act in a timely fashion found in Rule 3. All documents will be filed electronically, and parties and arbitrators have the option to hold any hearing or session by video, phone, or in person, or in a hybrid format. The updated arbitrator declaration includes an express commitment concerning availability of the arbitrator and a 2-year calendar clearly showing that arbitrator's available dates. A number of other provisions support the goal of reducing the time of proceedings by encouraging proactivity by arbitrators and parties. For example, case management conferences under new Rule 31 are expected to occur regularly throughout the case to identify uncontested facts, clarify and narrow the issues in dispute, or address any other procedural or substantive matter. Another example is new Rule 46, which provides a procedure to consolidate like cases into one single proceeding or to coordinate specific aspects of parallel cases. The time limits throughout the rules have also been clarified, and in some instances they have been reduced. In particular, a tribunal is expected to render an award as soon as possible and within 240 days after the last submission, if that submission deals with merits and jurisdiction. Most procedural decisions must be made in 30 days, and these are clearly set out in the rules. Rule 12 requires the tribunal to use best efforts to meet these time limits, and if it requires an extension, it must advise the parties in writing of the special circumstances justifying a delay and the length of the delay required. Likewise, Article 11 allows parties to mutually agree on an extension, but if there is no consensus between them, they must request an extension of time based on a reasoned application that is made before the time period in question has expired. Rule 52 sets out relevant factors for cost decisions. These include the outcome of the proceeding, the conduct of the parties, including whether they acted expeditiously, the complexity of the case, and the reasonableness of costs claimed. Note in particular that new Rule 52 sub 3 allows a tribunal to make interim cost orders at any time, and these ultimately become part of the enforceable award issued by the tribunal. A new provision specifically dealing with security for costs has been added as Rule 53. Under this provision, a tribunal must consider all evidence related to the circumstances surrounding the request, including a party's ability and willingness to comply with an adverse decision on costs, the effect that ordering security for costs may have on a party's ability to pursue its claim, and the conduct of both parties. The new rules also extend transparency in the process. Awards will continue to be published with consent of the parties in ICSID convention cases, as required by the convention. But if neither party objects to publication, their consent will be deemed and the award will be published. If there is an objection, ICSID will extract the legal reasoning as it has done in the past. All orders and decisions will be published. These will be published with redactions agreed by the parties, and the tribunal is available to decide any dispute about redactions. The amended rules also provide for publication of a party's own main pleadings with redactions agreed to by the parties or decided by the tribunal. And hearings are open unless either party objects to an open hearing. Finally, the rules incorporate a new expedited arbitration chapter. Parties may consent to apply this chapter to their ICSID convention or additional facility cases, or they could consent to applying selected provisions from within the expedited arbitration rules. If followed fully as written, the expedited arbitration rules would reduce the time of a case by 50%. The additional facility rules have also been updated. Note in particular that the new additional facility rules will significantly broaden access to the additional facility in two main respects. First of all, additional facility cases can now involve parties that are both from non-ICSID member states. In other words, they no longer are limited to cases where one of the claimant or respondent is either an ICSID member state or a national of a member state. Second, a regional economic integration organization can now be a claimant or a respondent in an additional facility case, based, of course, on its consent in a treaty or a contract. We have also significantly updated the fact-finding rules and made them standalone rules separate from the additional facility, and they have their own set of administrative and financial regulations. Under the updated fact-finding rules, a party can jointly request with the other party to have a fact-finding committee struck to determine a procedural protocol and ultimately to make specific fact findings in a dispute that will lead to resolution of the overall case. Finally, we have adopted an entirely new set of investor-state mediation rules. These are available broadly between parties in a dispute relating to an investment, and the parties do not need to be nationals of a member state or to be a member state under the ICSID Convention. The mediation can be commenced under an existing agreement, or it can be agreed to by the parties on an ad hoc basis. And the parties can agree to commence mediation at any time in the process, including if they wish before an arbitration, for example, perhaps during a cooling off or consultation period. Or they may do mediation if they wish in parallel with arbitration. These mediation rules are aligned with the formal requirements of the Singapore Convention, and this will, of course, enhance the enforceability of any resolution reached through mediation. We hope this short video provides you with a flavor of the new amendments, and we encourage you to review the new rules and to follow our website for further information. If you have any questions or comments, we encourage you to send them to us, and if you are interested in setting up training on the rules, please let us know. We look forward to working with all stakeholders in implementing these rules, and we believe that with our joint efforts, these will be a significant step forward for parties, for arbitrators, for the Center, and indeed for the investor-state dispute settlement system. Thank you.